So hi, everyone. We'll go ahead and get started. So I'm Gina Brown. I'm the Colorado Legal Assistance Developer for Elders, and welcome to our second webinar in our series of webinars for Colorado legal assistance providers. As most of you know, the Colorado Legal Assistance Program is funded by the Older Americans Act and provides legal services to Coloradans age 60 and older, particularly those with high social and economic needs. But before we introduce our presenter today, I want to do just a little bit of housekeeping. As you may have noticed, today's program is in the Zoom webinar format and not the meetings format. So you can't do video and you're not on sound. But what we do ask is when you have questions, and we encourage you to ask questions during the program, please try to use the Q&A function in the webinar, one of those buttons, hopefully down at the bottom of your screen. And if you have any technical issues, feel free to chat directly to me, Gina Brown, and I will also drop my phone number and my email into the chat to you all. So if you need to reach me off Zoom, you can grab me right away. Okay. So I do want to introduce David Godfrey, who is the director of the American Bar Association Commission on Law and Aging, and he's going to talk to us about capacity and ethics. Before joining the ABA, David managed elder law programming for the Access to Justice Foundation in Kentucky. And as I'm sure many of you know, David is an amazing resource for elder law practitioners and has been a huge support to me as I have started my job here in Colorado as the legal assistance developer. David, take it away.
Thank you. Let me set up and share my screen. And good. Let me get back to the first slide. That'll help. So the general overall topic this afternoon is protecting clients' capacity and ethics. So what is capacity? Capacity is the ability to make an informed decision or choice, the ability to give informed consent. If you're looking in the model rules for professional conduct, you won't find capacity or incapacity or diminished capacity really defined, but you will find in the definitions informed consent, which is the ability to make a choice based on an understanding and knowledge. Capacity is a spectrum from comatose to genius, and we're all someplace on that spectrum. Hopefully we're closer to genius than we are to comatose, but we'll also vary in several different ways where we're at on the spectrum, from totally unable to respond to the world's greatest expert. Capacity is situational, the capacity to do what? To make what choice, to make what decision. So for example, I can drive the pretty little red car, but I probably can't fly the Zeppelin. So just because I can do one thing doesn't mean I can do another. Just because I can't do one thing doesn't mean I can't do the other. And if you take that and you start looking at it in a legal concept, can the person consent to marriage? Can the person make a will? Do they have the capacity to sign a power of attorney? Do they have the capacity to incur debt or to defend themselves against a debt collector? It depends on what the situation is, what level of understanding of the options, risks, benefits, and consequences of the choice that they're making are. You bring into this the concept of supported decision making. There was a news story out of Florida recently. Someone went out for a ride in an airplane and the pilot passed out, had a medical emergency and lost consciousness. And the passenger was able to push the button and talk to the tower and go, "We're doomed because I don't know how to fly an airplane." But the staff on the control tower were able to talk the passenger through the process of landing the airplane successfully and being able to for everybody to walk away from it. So capacity is supplemented by support. In that case, the support was stepping the person through what the options were, how to do them, giving them advice on how to do it. But the person still, the passenger still had to actually fly the airplane and successfully landed it. So capacity is transient. It comes and it goes. Capacity can be impacted by a lot of things. Illness. All of us have had that bad day when we were really feeling terrible and our judgment or ability to make decisions was really diminished. Pain in the population that I frequently work with older adults, urinary tract infections, UTIs, apparently create a pain so great that people have a hard time communicating that they're in pain. So it dramatically impacts their capacity or their ability. A lack of sleep, medication, substance use or abuse, stress, the time of day, grief, depression, mental health. You look at that picture and you look at the goofy look on my face. Back in 2015, I had some major spinal surgery, and there was two pieces of good news. There was a piece of good news and a piece of bad news on the pain medication. The pain medication was incredibly effective. It really worked. But if you look at the look on my face, and they handed my phone back to me 2 days after surgery, and I started posting things on Facebook, which live on forever, and sending text messages, which kind of live on forever, it's clear that something was interfering with David's normal level of judgment and capacity. The additional good news is when the pain meds went away, the capacity came back. But medication, substance use, or abuse can dramatically impact someone's capacity, their ability to make decisions and exercise good judgment. It's important in all of this to remember that adults have a right to make bad choices as long as they understand the choice that they're making. My father had a list of about 5 reasons why no reasonable person should ever own a convertible. There's no room in it, they cost more money, they leak, they're noisy, and I understand all of those things and always wanted to own one. So when he died, I took some of my inheritance and bought the little white car. The Panda only fits in the back seat because he has squishy legs. There's virtually no leg room in the back seat. But adults are allowed to make bad choices as long as they understand the risks, benefits, consequences of the choice that they're making. So just because someone is making a choice that others consider to be a bad choice doesn't mean that the person lacked the capacity to make that choice. That's a separate determination of whether they understood what they were doing. When we're looking at capacity, there's a fundamental entry level question, and that is, does the client have the capacity to contract for your services and the ability or the capacity to complete the legal transaction? So far as a capacity to contract for your services, does the client know that they have a legal issue and they want help, that you're a lawyer and that you could help, and that they want you to help? Now, if you're an attorney in private practice, there's a 4th condition I'm going to add to that, and that is that you're going to expect to be paid and that they know they need to pay you. For the legal aid and pro bono, the public service community, that's really not a concern. We don't worry about whether our clients understand that the service has to be paid for, because that's the business that we're in, is providing that service without charge. If you have a client that can talk about those elements of, I have a problem and it's a legal problem, you're a lawyer, would you please help me? I think you have a client that has the capacity to contract for your services. You may have a client with diminished capacity that then has difficulty making some of the choices to complete the legal transaction. And if so, then you go into Rule 1.14 of working with a client with diminished capacity. There are some legal functions that have specific legal standards. Testamentary capacity is the classic one. At the time of executing a will, the individual must know the natural objects of their bounty, understand the nature and extent of their property, and to connect those elements sufficiently to make a disposition of the property according to a rational plan. I always loved the old English, the natural objects of their bounty. In other words, do they know who they are and who their family is, what they own, what they want to have happen to what they own at the time of their death, and that the document they're signing is a plan for that to happen? That's really the elements for a will. Some states will have a little more detail or a little less detail. based on statutory law or case law, but that's going to kind of give you the generality. The phrase of sound mind is still quite commonly used, but it's really, if you start looking for a definition of it, nobody really knows what it means. Power of attorney, most states use the contract standard of capacity that for entering into a power of attorney. Some courts have used a lower standard, which is the capacity to make a will. Capacity to contract is a little higher because it requires an understanding of the nature of the business being transacted and its impact. But for a power of attorney, it really comes down to, do they understand that this document names an agent for them, that that agent can bind them to a decision? The signature of the agent is the same as the signature of the person, and they can't undo that any more than they could undo something that they had signed themselves. And you can break a contract, you can breach an agreement, but there are frequently penalties that go along with that. The agent is signed, those same obligations or penalties apply. That they can revoke the appointment. And this is something that in talking across the country over the last 20 years, a lot of lawyers don't make clear to the person who's naming an agent and a power of attorney is, as long as you have the ability to say, I don't want that person to be my agent anymore, you can revoke the appointment, you can cancel it. And the nature of the authority they're delegating, and this is where signing a power of attorney changes from being a 10 minutes, here's the form, this is where you sign, to sometimes a 2 or 3 hour discussion by going through authority by authority with what is the agent empowered to do or not empowered to do on behalf of the person. And we encourage a lot of thoroughness with that and customizing the power of attorney so that the authority that's being granted is what the person feels comfortable with. And there are some specific powers that have a high risk of abuse or exploitation, such as transferring property, changing beneficiaries, making gifts, that we urge a real careful conversation and understanding on behalf of the person to make sure that they're truly comfortable with granting that authority, and they're not doing it just because, well, it's on the standard form and everybody uses the standard form. Those are powers that are most frequently abused or exploited. Contractual capacity, the ability to understand the nature and effect of the act and the business being transacted. And the more complicated the transaction, the more complicated the understanding needs to be. That's sort of obvious. A capacity to convey real property. I had an email inquiry last night from someone on an older client who signed a deed and didn't understand what the deed meant. And now, a good number of years later, the relationship with the family member that they gave the house to has deteriorated to the point of ending up in an eviction action. And they're going back and looking at, did the person understand at the time that they signed the deed the nature and effect of it? In other words, you're transferring rights and real property to another person. You no longer have the right to use or occupy the property. You're not able to reclaim the use or occupancy of the property. And that surprisingly comes up in home transfers between family members, of the person not understanding that when I sign this deed, they have a right to evict me and throw me out of my own house. So if you're involved in this, either in the transfer process, you want to make sure that the grantor understands those elements. Or if you have one of those cases that comes in through your office, you want to be able to go back and look at, did the person understand what they were signing at the time they signed it? And those are really the essential core elements of understanding for conveying real property, that encapsulate what the conveyance of real property is. The capacity, if not stated, is understanding the essential elements of the legal action, understanding that there are options available, the long-term consequences of the choice that they're making, and fundamentally being able to make a choice. It is rare, but you will run into people who can hold A surprisingly intelligent conversation, but at the end of it, simply can't make a choice. When you interview that client and you spend a couple of hours with them and you get down to the bottom line and you discover that they can't make a choice, it's a client that you'll never forget. In 9.5 years, I had 12,000 hotline clients, and there were 2 or 3 of them that fall into this category, and they are very memorable. But it does pop up where you have someone that simply is unable to make a choice, but yet is still very able to communicate. So a case example, Bill and Edna have been married for 62 years. They arrive for your meeting, and Edna does all of the talking, saying that they want to leave everything to each other, and when the second one dies, in equal shares to their 3 children. Edna wants to be named as the agent and a power of attorney and as the healthcare agent for her husband, Bill. For her power of attorney and her healthcare agent, Edna wants to name their oldest son. You ask Bill what he wants, and he says, whatever. Well, Edna says, we'll be fine. You ask Bill the names of his children, and he responds, ask Edna. You ask what bank their life savings are in, and he turns to Edna and says, you know that, don't you? What are the red flags here that there might be a capacity issue? So Edna speaking for both of them is certainly a red flag, but there are a lot of relationships where one of the spouses does most of the talking. Just ask my spouse about that, and they can probably tell you, you can't get me to shut up. Edna's choice of agents, her wanting her son to be her agent, but her wanting to be the agent for her husband, his deferring to her, his ability to answer basic questions. Who's your family? Where's your money? Kind of basic, simple questions that you expect most people to be able to do. Any or all of those are red flags, things that raise a question, not necessarily that this person doesn't have capacity or has diminished capacity, but there's a question here and it requires a little more conversation. Capacity assessment is something we do normally and automatically. Anytime we engage in interactive communication with someone, we're asking questions and answering them. They're asking questions and we're answering. Our brains are constantly checking to see, did they understand the question? Does the answer they're giving us make sense based on what we know of the circumstances and the question that was asked? And as long as those things show up as a yes, we know the person has capacity and it's a natural flowing conversation. But when something interrupts that, and it's one of the reasons that, what's the old saying? We have one mouth and 2 ears, so we should listen twice as much as we talk. Ask questions, listen to the answer, and analyze the answer, and it'll give you a lot of clues on this, and especially alert you to when there are red flags. So what do the model rules of professional conduct say about capacity? The picture of the 2 eagles was taken about a mile from my house down along the Potomac River. In terminology, informed consent, this is in the definition sections of the model rules. Informed consent is defined as an agreement by a person to a proposed course of conduct after you've communicated adequate information and explanation of the risks, and I say benefits, and reasonably available alternatives. They have to know that there are options or alternatives available to the proposed course of conduct. The night before that surgery, the surgeon is sitting there and he's going through his informed consent disclosure, and he goes through all of the treatment options. And I look at him and I said, there's one other thing that you've missed. He said, oh, what was that? Well, he could do nothing. He said, oh, that'd be a really bad idea, and I'd never recommend that. I said, yeah, but it's always an option, is doing nothing. And it was kind of an eye-opener for a very, very brilliant neurosurgeon. I was very lucky to have him. That's an option that I think people sometimes should know about. But do we know what all the options were and that options and alternatives were available? Rule 1.4 obligates a client to keep a lawyer to keep the client reasonably informed about the status of the matter and to explain it in a way that permits the client to make informed decisions, to give informed consent regarding the representation. Depending on the complexity of the legal issue and the sophistication of the client, the level of explanation will vary dramatically and change. So this is really an important piece of the rules. Rule 1.2 says that the client always has the right to make some of the decisions. The model rule says the client has the right to make the decision about the objectives or the goals of the representation. What are we trying to do here? And that the lawyer shall consult with the client as to the means by which that goal or objective is pursued. The second clause of that varies a little bit from state to state. Some states leave it up to the lawyer's independent judgment to decide the means by which the objectives or goals of the representation are pursued. But the model rule is worded as it is there. So how do we get capacity from that? We have the client has capacity if we are able to communicate with them in a way that the client can understand to the degree necessary for the client to give informed consent regarding the objectives or goals of the representation. And if not, the client has diminished capacity. I wouldn't say no capacity, they have a diminished capacity. And then rule 1.14 kicks in, which is a client with diminished capacity, working with a client with diminished capacity. A lot of times when we start talking about client capacity, people jump immediately to rule 1.14 because capacity isn't defined any place. But rule 1.14 is really, what do you do when you have an attorney-client relationship and your client has diminished capacity? And the client may have diminished capacity at the time the relationship is entered into. A client who is comatose, you may be appointed to represent. You get a court appointment to represent that client, and all of the ethical responsibilities to that client attached to that client. And then rule 1.14 gives us guidance on how to apply the ethics rules and how to go about representing that client. The first step is, to the extent possible, maintain a normal attorney-client relationship. Work with a client with diminished capacity the same way you would every other client. Rule 1.14b, and this is a part of the rule that is sometimes difficult to interpret. When the lawyer reasonably believes that a client has diminished capacity and is at risk of substantial financial or other harm unless action is taken and the client can't adequately take that action to protect their own interests, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. A gigantic word of caution: unless you are an expert in guardianship practitionership or conservatorship cases in your state, try to avoid ever seeking appointment of yourself or someone else as conservator or guardian of your client. It's the most common ethical trap that lawyers get into as they're working with a client. The client has a healthcare crisis. They get themselves appointed as guardian or conservator of the client, proceed with the case, and then a family member or loved one steps forward and files an ethics complaint saying that the lawyer was making sure that their interests were met, especially attorneys that are getting paid a fee, making sure that the case was completed so their fee could be paid, and not looking out for the best interest of the client. Now, there are guardianship conservatorship practitioners who are experts in this, who know how to carefully navigate the system and the ethical traps that are there. But unless it's an area that you really work in a lot, it's something that I encourage you, if that ever happens, ask the court to appoint a guardian ad litem, let the guardian ad litem make a decision of whether a conservator or guardian is necessary, and let somebody else file for it. Filing for guardianship or conservatorship of your own client is an ethical trap that's really easy to fall into. The comments to Model Rule 1.14 actually have a lot of understanding and a lot of depth in it. In comment 1, client with diminished capacity often has the ability to understand, deliberate, and reach conclusions about matters affecting the client's own well-being. This is, capacity is a spectrum, and with help and support, clients who have some diminished capacity are still also very much able to make some decisions or choices if we help them with understanding and explanations. Also recognizing that age and incapacity are not the same. Advanced age, persons of advanced age are often quite capable of handling financial matters, but may need special legal protections regarding major transactions. Comments 2 and 3, a client with a disability does not diminish the lawyer's obligation to treat the client with attention and respect. When we listen to complaints or dissatisfaction with lawyers from persons with disabilities, they frequently complain that the lawyer disregarded them and concentrated on others who were in the room. The client may wish to have family members present to participate in discussions. We always say it's important to spend some time with the client individually to make sure that there's not undue influence and that the communication that's taking place, the information you're being given, is truly what the client wants and not what somebody else wants them to do. But the client may ask that other people be there. It does affect privilege, meaning that you could be called to testify unless the presence of the person is essential to the representation or essential to the communication working with the client. It doesn't change confidentiality. Confidentiality actually applies to everything that we learn about our clients, no matter where or how we learn about it. If you read it on the front page of the newspaper about your client, you're obligated to protect that by confidentiality, despite the fact that you didn't learn it from the client. Third-party callers calling to tell us about a client. We can listen to them, but we can't tell them what we know. And I've urged lawyers to give that explanation of, I'd love to hear what you have to say, but ethics prevent me from telling you what I know. But sometimes the input that you get from a third party is very, very important in understanding what's going on. So how do we assess capacity? As I said earlier, we do it every time we communicate interactively. There's no simple test. When I first started doing this work 20 plus years ago, I was looking for the 10 simple questions that would tell me whether my client had capacity or not. Those 10 simple questions are a screening tool. They're not a diagnosis. You have to look to the totality of the circumstances, the ability to communicate, to give informed consent. And when you're really in doubt, and you'll have a handful of clients that you're really not sure whether they understand or don't understand, sometimes you need to seek guidance before moving forward. We do publish a handbook on assessment of older adults with diminished capacity. The second edition came out this last year. If you'd like to purchase a hard copy of it, you can do so on the ABA website. If you're working in a nonprofit legal aid program and you would like an electronic copy of it, email me. We send you a form that you have to fill out and sign. You send that back and we'll send you a PDF of it free of charge. Sometimes people see the PDF and then they go, it's really worth $49.95 to have a printed copy of this. That's your choice. I have books that I have PDFs of that I've gone ahead and purchased hard copies of. But for legal aid, nonprofit, pro bono, email me, david.godfrey@americanbar.org, and we will send you out the form that's necessary for us to go ahead and send you back a PDF of it. In there's a long checklist. Observational science. Does a person have difficulty with short-term memory? This is usually, can they remember what they've said and where they're at and where they're going? Language and communications problems. Language becomes an issue, aphasia or word finding becomes an issue. Uh, Comprehension or understanding problems, understanding issues. Are they able to understand reasonable explanations that you would expect a person of their life experience, education, and cultural background to easily understand? And if you take time to give a more detailed or broken down or simplified explanation, are they able to understand the facts that are being given to them? And if not, you have a sign of a potential diminished capacity. A lack of mental flexibility. This is, an extreme inability to change from one topic to the next. And one of the practice skills for working with clients with diminished capacity is to focus on one issue at a time, maybe only one issue or one question in an individual meeting, and to shift from time to time, uh, to schedule another meeting to move on to the next topic or the next issue. And a general disorientation. Do they know who they are, where they're at, what day it is, what season it is? This is the orientation times three: person, place, and time, um, which is part of a screening tool, but not the whole thing. And you'll see a lot of documentation from other professionals that person was oriented times three or times four, and that just means that the person knew who they were, where they were at, and what time of the day it was, and what season it was. It doesn't mean that they understood anything else. But if they lack that, it becomes a question or a concern. And then we go through 2 years of remote work, and people literally, in some cases, hardly leaving their bedroom. And it was real easy for people to become disoriented and not know whether it was spring, fall, or winter. Summer's usually easier to tell, but because we lost those touchstones to the outside world that normally connect us to such things. There's a couple of uncomfortable facts. Research shows that financial judgment peaks at age 52. For some of us, that ship has long ago sailed. The second uncomfortable fact is decline in capacity. Credit scores, on average, this was a study by the Penn Memory Center in Philadelphia. They took a couple of hundred people who had been definitively diagnosed with Alzheimer's disease. They had a decline in mental capacity, and they had an MRI or CT result that showed positive for plaques and tangles in the brain, for amyloid plaques in the brain, which is a definitive diagnosis for Alzheimer's disease. And with their permission, they pulled credit scores on them. And they found that credit scores started to decline 7 years before the average person was diagnosed with dementia. And those are a score of collections judgment, credit utilization, timeliness of payment. So a diminishment of financial capacity is frequently the canary in the coal mine. It's the first sign that we see that something is changing. And unpaid bills are the most common. And this happened to my parents. They came home from lunch one day and the lights had been turned off. And my father asked my mother, "Did you pay the electric bill?" And she said, "Yeah, last month." And they sent me another one and I'd already paid it. So I ran it through the shredder. She'd done that about 3 months in a row. So unpaid bills or undeposited income used to be a factor. With direct deposit, that's less of an issue. We'll see people with very large checking account balances and unpaid bills. Unusual spending is less common, but it does come up. When I was preparing this slide, there was a case that came across a person whose car was in the shop being repaired, collision damage. So it was going to be a couple of weeks before the car came back, was surfing social media one night, and a red Ford pickup truck from the local dealer popped up online, and she went, "Oh gee, I've always wanted to own one of those." And she entered her driver's license information, her credit card information, her car insurance information, and clicked buy it now. And they showed up the next day and said, "Congratulations, we're here to deliver your new truck." And she couldn't remember buying it. But the information that had been entered was information that only she had control over, and apparently she had. That is much less common, but it does happen. And I've seen some really tragic results there where people spent through their life savings in a relatively short period of time, and when asked about it, couldn't understand how it happened or where the money went. Um, you will rarely see those. So financial management abilities, problems with everyday arithmetic, addition, subtraction, basic percentages, decreased understanding of financial concepts. They understand the difference between a 3% rate of return and a 1% rate of return. 10-year treasury bills are up to 2.93%. Decreased comprehension of ordinary financial documents. When they get a credit card statement, can they figure out how much they owe? Or they get the explanation of benefits for health care. Can they figure out what their patient obligation is? Which is hard to do. Diminished awareness of financial risks. And this is a big factor that the financial services industry, stockbrokers and investment advisors are looking at is, do older adults understand that the high rate of return investments sometimes come with very high risks? And certainly they don't want to tell people you can't buy that because you're old. But they want to make sure that the clients that are taking on those higher financial risks understand the risk that's associated with it. It's a diminished capacity has been exploited especially in the investment world, with older adults being sold very high risk investments. Emotional functioning, obvious emotional distress, emotional lability. This is laughing at things that are tragic, crying at things that are funny. We all do that to some weird extent, but for a person who's experiencing a change in capacity, it'll become very noticeable and very marked, and something that'll really stand out. Behavioral functioning, delusions. These are strongly held personal beliefs that have no rational basis in fact and can't be dissuaded or changed by fact or verification. Hallucinations. My mother had Parkinson's and a related dementia, and hallucinations are quite common. And we didn't know that. So when she was sitting there going, "You can't sit there, your grandmother's in that chair," we really didn't have a clue what was going on until we went and got some advice and talked to some experts, because the presence of that person was very real to her. But it can also be sounds, smells, tastes. The coffee tastes funny, there must be something wrong with it. Or I smell smoke, and it's very real to that person. It's a part of their perceived reality. Poor grooming or hygiene, and markedly inappropriate social behavior. Poor hygiene and grooming, poor hygiene and grooming. There's an old Far Side cartoon that makes the rounds. A guy sitting on the side of a bed, and there's a sign pinned to the wall that says, "Pants go on before shoes." When cognitive function starts to become impaired, remembering that sequencing can be difficult. And people will sometimes stop showering, bathing, changing their clothes, because laying out clean clothes, undressing, getting in the shower, getting clean, drying off, getting dressed, and getting everything back in the order that society expects it to be in can become difficult. And it often results in poor grooming or poor hygiene. Markedly inappropriate social behavior. My grandmother, who had dementia, would go up to men in the nursing home and go, "It's kind of cold. You want to come snuggle up in my room tonight?" Which was totally out of character for her and a totally inappropriate social behavior. But it was an impact of Alzheimer's disease on her behavior. Other observational and notes from third parties. This was added in the second edition. And it's really important. And this starts with the person who greeted them at the front door, the person who answers the phone, talking with family members and caregivers and going, anything I should know, what's important, what's happening, how well do they do on paying their bills, on remembering who their family is? Are there issues with them losing things or forgetting things? Because those can be really, really helpful in understanding what's happening with the person. The mitigating factors, and we kind of went through these in my Viking slide earlier, social and environmental factors. Don't forget educational, cultural, and ethnic barriers can make a huge difference in the understanding of a person and the ability to understand complex questions or issues, especially in the legal arena. The more serious the issue, the higher the functioning. Is the decision consistent with long-term values? If not, can they articulate a reason? Is the decision objectively fair? Will anyone be hurt by it? This is the client who comes in and wants to change their will and cut one of the kids out. Are they consistent over time? And if not, is the client clearly able to articulate a reason for the change from their long-term pattern? And is the decision irreversible? And two screaming examples here. A will is reversible until you die. Transferring a house in most states isn't. You can't turn around and ask for it back unless you've reserved the right to ask for it back. And can they truly appreciate the consequences of the decision that they're making? There's a little score sheet that comes up at the end. A few other little issues, and I'm doing okay on time. Undue influence, vulnerable adults. Sandy Glazier, Tom Dixon, and Tom Sweeney wrote this. It's the use of power and control to exploit trust, dependency, and fear to substitute one person's will for the true desires of another for the purpose of gaining control or benefit. Undue influence is slightly different. These are, 4 different ways that people are financially exploited. Pure financial exploitation. In most state adult abuse codes require some vulnerability. So if you're looking at an elder abuse or adult abuse code, they almost always require vulnerability. Sometimes that vulnerability is based purely on age, but usually it's based on a limited ability to protect or defend yourself. Financial exploitation straight out doesn't require a person in a position of power or influence. It can be a stranger. It doesn't require an intentional lie or material misstatement of fact, but it's the theft or the use of money or the property for the benefit of another person, of a vulnerable adult. That's financial exploitation. Separate cause of action is lack of capacity. Lack of capacity cases are really, really hard to prove because you have to prove that the person was a victim of a theft or the use of property and money for the benefit of another person. And at the time it happened, they were unable to form informed consent. And that can be really difficult to document and to present evidence on. Undue influence, which is a viable legal cause of action in all 50 states, either by statute or under case law. The person must have some vulnerability, but they also must have capacity, because undue influence is changing the free will or choice of a person. So if the person is totally incapable of communicating a choice, an undue influence claim will fail. Pretty much every state requires a person in a position of power or influence. Doesn't require an intentional lie or material misstatement of fact or withholding of material fact. In fact, frequently in an undue influence case, the statement that's made is 100% true. If you don't do what I want to do and give me what I want, I'm going to either drop you off at a nursing home and never come to see you, or you're never going to see your grandkids again. They're true statements. They're incredibly powerful, and people do really, really regrettable things as a result of those threats. And they result in the theft or use of the money or property of the person for the benefit of another. Fraud is a separate cause of action. So you've got potentially 4 different causes of action. Fraud does not require vulnerability. A lot of victims of fraud are incredibly intelligent, well educated, and on the top of their game intellectually. It doesn't require a person in a position of power or influence. It's optional. It may be a person in a position of power or influence, and it may be an email from your new best friend halfway around the world that does require an intentional lie, material misstatement of fact, or withholding of fact that results in a theft or the use of money or property for the benefit of another. So there's 4 potential causes of action for recovery of money or property that's been lost or stolen. Accommodating cognitive impairment and working with the client, begin the interview with simple questions requiring brief responses. Generally, you're going to work at a slower pace. Allow extra time for responding. Again, word finding and putting thoughts and ideas together is slowed by diminished capacity or cognitive impairment, but it's not necessarily stopped. And we have a tendency culturally to avoid the silence. Sometimes you have to ask the question and wait. And it might take a minute or 2 minutes for the words to come or the thoughts to form. And they may talk about something else and come back and go, now I remember the answer to your question. And if you think about it, we probably all do that to some extent, but cognitive impairment or decline in cognitive ability will magnify that or make it stronger. Break information into smaller, more manageable segments. One issue at a time. You feed the information back, repeat it, paraphrase it, summarize it to check for the accuracy of the and understanding. If it's not understood or incompletely understood or misunderstood, provide corrective feedback, check again for understanding. It can be helpful to provide summary notes and information sheets to facilitate later recall. If you're doing that, be aware of literacy and also the person's ability to read or follow. It's sometimes helpful at that point to ask, is there somebody else that I could give that you would feel comfortable with me sharing with you the information we need for the next meeting and my notes about this meeting? I wouldn't do it without the client's permission, but if you feel the client understands the risk of granting that permission, it can be really, really helpful in accommodating it. Schedule appointments for the time when the client's at their peak. I'm an afternoon person, so this is probably the best time of the day for me. I have a colleague who's a night person. If you want to get the best out of her, you talk to her at about 7 o'clock at night. And when I was doing direct legal services, we did appointments from 8 o'clock in the morning till 7 or 8 o'clock at night. Depends on what worked best for the client. When possible, meet the client where they're most comfortable, and frequently that's their home. It often makes the client more relaxed, optimizes their decision making, and provides you with input about their real world functioning. It also puts them in an environment with their greatest support structure, their calendar and their stack of post-it notes that they use to help accommodate themselves. The role of decision supports or supported decision making is new in the capacity handbook. And we do entire programs just on that. But we can support and enhance capacity by working through supported decision making concepts, and it's something we strongly encourage you to do. Avoiding implicit bias and capacity assessment. When we meet people, we form an initial impression shaped by visible traits, and those are associated with cultural stereotypes, and those cultural stereotypes bring with them a set of preconceived behaviors, understanding. And it's really important when we're working with adults who may appear different or be older, to not let those preconceived notions shape the person's ability to understand, make choices. Avoid the isms, and when in doubt, follow up with the client. Work in accordance with Model Rule of Professional Conduct 1.14 and consult with other professionals as necessary. Sometimes it's helpful to ask the person who they turn to for support. So a little bit about the ABA Commission on Law and Aging. We lead the ABA's work on strengthening and securing the legal rights, autonomy, and dignity of older adults. The Commission accomplishes its work through research, policy development, advocacy, education, and training. You can support our work. And if you're not an ABA membership, we do a lot of continuing legal education programming, and for legal aid, public interest, solo and small firm lawyers, ABA membership's $150 a year or less. And that includes access to a library of over 600 CLE accredited webinars. Questions?
Thank you, David. That was fabulous. There is one question in the Q&A, and I'll go ahead and read that, but I'll also do just a little bit of fill here for a moment to let you get a sip after going through all of that terrific material for us. I also want to do a plug also for the book that the ABA has done, Assessment of Older Adults with Diminished Capacity. We sent, I think, 9 copies to different Colorado legal assistance providers in the last couple of weeks. So there are a number of hard copies at offices around the state. Let me know if perhaps you did not get in on that buy and you would like my office to help you with that. And also that PDF copy is a great free resource. So I'm happy to help connect you with that as well. And as a former ABA staffer, I also need to plug the ABA and the low-cost membership and the terrific free programming that you get access to as a member these days. So that's all great. David, would you like me to read the terrific question from Claire that's in the Q&A?
Yeah,
okay,
that'd help.
So Claire asks, she says she's confused about the confidentiality that is due to a power of attorney acting on behalf of a client with diminished capacity. When the client has diminished capacity and the client can't tell you what they want, and their power of attorney is telling you things that show the power of attorney is acting against their fiduciary duty to the client, do you have the ability to violate the confidentiality to report the power of attorney to Adult Protective Services? And she mentioned, say, it could be the context of transferring the house of the client who is on long-term care Medicaid.
The first fundamental question that comes up is, who's the client? Did you have an attorney-client? Do you have an attorney-client relationship with the grantor of the power of attorney? And is it clear that that's where your attorney-client relationship lies? If so, and you believe that person is being materially exploited or going to be harmed in a material way, Rule 1.14 would say, and you can dig into the comments and find it, that reporting to Adult Protective Services is permissible. If your attorney-client relationship is with the agent, or you have a relationship, an attorney-client relationship with both the client and with the agent, if you have a relationship with both the client and the agent, you have a potential conflict of interest between two clients on a related matter. And in most cases, the answer there is to explain to the client, if you persist in this, to the agent, if you persist in this course of action, which I believe is contrary to the best interest of, or in violation of the law, and Medicaid regulations are law. So if it's a transfer that's contrary to what Medicaid regulations say are allowed, if you persist in doing this, my only choice is to withdraw, and I can't continue to represent either of you. If your relationship is with the agent and the agent only, you can't assist a client in the perpetration of something that's a fraud or violation of statute or law. You're forced into explaining to the client what's happening, why you think it's wrong, and if they continue to persist in wanting to do that, you can't help them do it. The tougher question is, if you're representing the agent in their capacity as agent, that gets down a deeper rabbit hole. But again, you can't assist a client in the perpetration of a crime or a fraud. So if what they're talking about doing is wrong, whether you can report or not is a more difficult ethical question. You can withdraw. Say, I can't help you do that. I had a couple of occasions in my legal aid days where that was the answer that I had to give a client was, you can't do that, it's illegal, and I can't help you do it. If you want to do that, you're going to go need to find somebody else. And the two cases that it's always the bad ones that you remember. I had a couple of cases that ended really, really badly. After I withdrew, they went ahead and did bad things, and bad things happened. And if it weren't for confidentiality, we could write horrible books about the things that we see. So I don't know, as I get it, it's not an easy question, but that's kind of the best answer that I can give on that. When in doubt, most states have an ethics hotline or a quick answer, and you can always put together the question and submit it to your state bar association. And lawyers can get caught in a situation, depending on what the mandatory reporting laws are, where reporting is a violation of your ethics and not reporting is a violation of the law. And if you ever get caught in that squeeze, talk to the ethics folks at the Bar Association before you report.
Okay, thank you. I'm also happy here in Colorado to be a go-between with the bar as well, if that can be helpful. So we've got two more questions, David, and I know we only have 2 more minutes. So I don't know if you want to scan these 2 questions and pick one of the 2. The first is about seeking a guardian ad litem, and the second is about the tension between following the client's wishes and assessing capacity.
If I'm gonna when would I seek a guardian ad litem? If I really thought that my client lacked the ability to give informed consent and was in the midst of a legal action where they really needed a representative who was going to try to determine either what the client's wishes and values would be or what's in the client's best interest. And most guardian ad litems end up at best interest because it's really hard to document what a person's values and beliefs would have been. Tension between following the client's wishes and assessing capacity. And this one's actually running off the bottom of the box here for me there. You always want to follow your client's wishes if the client truly understands the risks and benefits of the choice that they're making, the long-term consequences of the choice that they're making. If you don't believe that the client understands the risks, benefits, and consequences of the choice that they're making, then you have a client with diminished capacity. And then you go into rule 1.14 and it becomes a bit complicated. You will hit situations, and again, it's the horror stories that come back that we remember, where the client understands the risks, benefits, and the bad consequences of the choice that they want to make, but they want to do it anyways. And then you have a personal ethical decision of whether you're going to assist a client in pursuing a course of action that you find morally repugnant, difficult. And I'll tell a short story. I spent 2 hours in a 90-degree living room talking with a client one afternoon about naming a son as the agent on her power of attorney and adding his name to her bank account. He was her only son. He was an alcoholic who had been arrested several times on drug charges, including cooking meth in her garage. And I advised her against it. And there were other family members who were trustworthy, ready, willing, and able to step in and assist her with managing things. And she insisted that he was her son and that his problems were her problems. And if she'd been a better mother, he wouldn't have all the problems that he had. And I kind of went, well, I need to go, we need to think about this one. You need to think about whether that's what you really want to do or don't want to do. And I need to think about whether this is something I'm really comfortable doing. And ultimately, I called her back and said, I think you know what you want to do, and I think you have a right to do it. But I can't sleep at night if I help you do that, because I think it's going to have a bad, I'm afraid, very afraid it's going to have a bad outcome. And I actually gave her the names and phone numbers of a couple of other legal aid programs, and someone followed her wishes and did exactly what she wanted. And the next time I met her, the social worker at the nursing home showed me the videotape of the son driving up out front, putting her in a wheelchair and leaving her on the front porch of the nursing home and driving away. And that was the day after he'd emptied all of her bank accounts. And that was exactly what I was afraid was going to happen. And it was a horrible outcome. And all I could do was try to assure myself that at least I didn't play a role in it happening. It's hard to turn a client down, but sometimes it's, you know, do you want to turn them down or help them and then later find out that horrible things happened because you helped them do what they wanted to do, when everybody knew, including my client, knew that putting her son's name on her bank account and naming him as an agent out of power of attorney was a bad idea. Those are tough ones, and we've run over a minute or two. I'm sorry.
Well, thank you for giving us an extra minute or two of your time, David. I really appreciate it. Thank you so much for this presentation. I know the folks in Colorado appreciate it, and we will likely be following up with you with questions and asks for a couple more copies of the book here quickly. If folks still have questions, feel free to drop them in the chat, send them to me, and I will try to follow up and get answers to everything from David. Unfortunately, we don't have time to answer every particular question today, but I will do my best to follow up. Those of you in Colorado, please join us next week, same time, for a program on discharges and evictions from assisted living facilities and nursing homes. It'll be another great one. And I've dropped the evaluation in the link. I will follow up with the CLE affidavit and materials for everyone later today. Thank you again, and have a great afternoon, everyone. Bye-bye.
Thank you.